of an intro into what you need to know about practicing real estate. Let me try to move this bar out of the way. Okay, can you see my screen?
Yep.
Okay, cool. So, I always have trouble. I never know where to. I know you can't see this, but my the pop-up window with everybody's picture is always in my way.
Oh, I hear you. Mine's in the way too. I usually drag it to the bottom, or you can minimize it, I think, too.
All right, so we're good now. So the first thing I want to talk about is advertising. So Ohio license law says that the brokerage name needs to be equal or greater prominence than the agent or team name. I think that prominence is a little bit vague, so nobody really has a full grasp of it. But when we go through some of these slides, you'll get an idea of what my position on predominance is. It needs to include the full brokerage name on all advertising and solicitations. Do you know what our brokerage name is? I can't hear you. Okay. You're muted, but that's okay.
Sorry, I'm thinking it's Keller Williams Living, but I've just been putting KW Living on everything. So number one.
Nope. So actually, our brokerage name is actually Living.
Oh, Living. Okay. That's why you said the
Keller
Living needed to
Williams,
be the biggest. Okay.
Keller Williams is a franchise name. So,
Okay.
and we're going to get to that in a moment here on some of the next slides. So, when we talk about advertising, we're talking about all advertising. That could be if you decide to wrap your car, your business cards, if you do a billboard, or even just promo product type of stuff. So knowing that Living is our brokerage name, if I was advertising, which one of these four options is the correct way to advertise my name?
It looks like the second one on the left.
This one here?
That's the one I would pick.
You picked right.
Okay.
So, yep. So Living is our brokerage name. Keller Williams has to be on everything because that's our agreement with the franchise. But when the state looks at it, they are only looking at the word living. They're not concerned. Oops. Sorry. They're not concerned with Keller Williams. They're only concerned with your name and
Living.
And the name Living.
Okay.
When you're advertising a listing, and then what's not on here is, so when you're advertising with our KW, our big Keller Williams logo, if that's your way of advertising the brokerage name, the entire logo itself is not relevant. Only that word living in the corner of that logo is what the state's going to be looking at to see equal predominance. So you have a big logo and you think, oh, that logo is definitely more predominant than my name. They're only looking at the living compared to your name, not the entire logo.
Okay.
Got it?
Yeah.
Cool. So advertising a listing. First thing is it should be your listing. If it's your listing, you can advertise it. It's in our listing agreements that you're allowed to advertise. Does the listing belong to Keller Williams Living? So if it's another agent has the listing and you wanted to advertise it, I've seen you do that. I know some of the productivity coaching clients do that. So that's fine if it's in Keller Williams. If it's a KW Living listing, you can advertise that. You just want to get permission of that listing agent before you start doing that.
Okay. So the way you said that just now, I want to make sure. It sounds like if it's not a KW Living listing, I shouldn't be, even if I was to ask that agent if it wasn't KW Living, I shouldn't be trying to share it. Is what it almost sounds like.
Well, no, I didn't get there yet.
Oh,
We're
I'm
jumping
sorry.
ahead. That's okay. First thing was your listings. You can advertise it because that's in our listing agreement. Second one is KW Living listings. You can advertise with the permission of the listing agent. Sometimes the seller might have specific ways that they want or don't want that listing advertised. So the listing agent would know that, and they would be able to give you permission if they're okay with you sharing that listing.
Okay.
Now, if it's another broker's listing, you can still advertise it. However, you need to have permission from the broker, not from me, the broker, from the listing broker.
From the listing broker.
Yeah, so that means not the agent. I mean, you can ask the agent for it, but the written authorization should come from the broker.
Okay.
Okay. And then yeah, like we talked about is do you have permission to advertise if it's a KW listing? But you should always have permission from whoever that agent or broker is. Anytime you send out any advertisements, anything in the mail, you should have a return address. And that return address cannot be your home address. It can't be a Starbucks that you normally sit out of. The only address we're allowed to use is our brokerage address, which is the Solon Road address. So any return labels for something advertising your business needs to have our office address as the mailing address.
Okay.
Social media has something called a one-click rule. So if you're advertising on social media, the best thing is Facebook and Instagram, I think, are the ones that most people use. And you should just have I think the best practice would be to have that branding with the KW Living or the brokerage name, and your name, the licensee name, on the picture of the house that you're advertising.
Okay.
That would probably be best practice. But the one-click rule basically says that within one click, the consumer needs to be able to identify who you are, that you're a licensee in the state of Ohio with Keller Williams Living. So if it's not right there, then within one click of that post, they should be able to tell that. So if you're advertising your website, for instance, within one click, they're going to get there and see that who you are. Got it?
Yeah, so that's a great point. And an advertisement, it's kind of a broad word, right? But what I'm hearing when I hear advertisement is any post that you basically are just discussing or anything involving real estate, basically. That's what I'm hearing.
Yeah.
Okay.
Yep. Exactly. Anything about your business, anything advertising a home, your services, anything
Okay.
like that.
Yep. Okay.
So now we're going to get into MLS rules. So we're past advertising. Do you have questions about advertising before I move along?
No, I'm glad that I'm here. That's all I'm gonna say.
Okay.
I did a post about closing on those properties, and it just has pictures of the houses, but it doesn't have the logo. So
yeah, that would be the best practice. I'd like to see you do that in the future.
Yeah, I'm fixing it now. I'm not about to get fined for something like this if I can avoid it. That is.
Yeah.
So.
All right. So MLS rules. We just need to really make sure that we're following the MLS rules with times. So we have the 48-hour rule.
Yep.
That means within two business days of you having a status change, you need to make that status change in the MLS.
Yeah.
Meaning you take a new listing today, I would recommend it's in the MLS today because that's how most people are going to find it. But
right.
Today's Thursday, so Friday, Saturday, you don't count Saturday, Sunday. Monday would be day 2. So by 11:59 p.m. on Monday, it better be in the MLS. If not, you can get audited and get fined.
Yeah.
There is a rule, it's a NAR rule called clear cooperation. So this trumps that 48-hour rule. Clear cooperation says that if you have a listing and you do any public facing marketing of that house, of that property, it needs to be in the MLS within 24 hours.
Okay.
So that trumps the 48-hour rule. So
Yeah.
that means if you took the listing today and today a sign goes in the yard, you no longer have until Monday at 11:59. You've done some sort of public facing marketing by sticking a sign in the yard. It needs to be in by tomorrow.
Yep. Got it.
All right. The same thing goes for status changes. So if you change it to if you got an accepted offer, you need to change it to under contract, allow showings, or under contract, no showings. You have the 48 hours to make that change in the MLS. Going back to the clear cooperation rule, that also means that if you do any posts, public facing posts on Facebook or Instagram or anything like that, any social sites, that once you have done that, then the 24-hour rule kicks in, and they're
I
taking
saw
that
a
pretty
few
serious.
coming soon things just today, and I was thinking to myself, I mean, I didn't think far enough into it to what you're saying and how it applies, but like now thinking about what we're talking about, now I understand they put coming soon, but now they have to have that in the MLS by tomorrow is what I'm taking away.
Maybe. I don't know what the circumstances are.
Okay.
What I've seen agents doing is they are doing those coming soon posts.
Yeah.
And so if I signed a listing agreement today, to have the listing start Monday, you can have the start date in the future, right? So that means I don't have a listing agreement today, so I can advertise it. And there's no clear cooperation violation because I don't have a listing today. Now, the other side of that, though, is that also means that the seller does not necessarily owe you a commission if somebody comes today and buys the house, because the listing agreement starts on Monday. So if somebody wants to go around you, you better have a good relationship and trust with that seller that they're not going to do that, because you earn your commission starting on the day that the listing starts. You can advertise it, and I've seen some agents doing that. Just the risk is that if somebody wants to go around your back and
they can
get to the seller, they can, and you're unfortunately out of luck because you don't have an active listing agreement.
Okay, thanks for the heads up warning on that. I wouldn't have thought that far into it.
There are MLS classes available if you ever need it. They do those periodically. There's also status temporarily off the market. Do you know how to use that one?
No, because I've heard, people doing it. Like when I was on the team, Karen had to do that with one of her listings, but I don't know exactly, I guess.
So temporarily off the market is, it's Christmas time and the sellers got family in this week and they say, we can't show the house this week because we got family in, or because the basement flooded and we need to get it cleaned up, or whatever it is. So that's how we use temporarily off the market. The MLS also has a rule that says if you're blocking off showings for more than 2 consecutive days, you have to use the temporarily off the market status. The exception to that would be if it's a rental property, and no showings until accepted offer. Also, I think there's an exception if it's a safety issue, that the house is just in really bad condition, that you can't allow showings. There's an exception for that. But in general, the average listing, we need to make sure that if we have to block off showings for more than 2 consecutive days, then we need to take it temporarily off the market. When you put it temporarily off the market, in the broker remarks, you have to say when it's coming back. Now
Okay.
that date could change, you know,
But
it
you
could
still have to
change
say
if
it.
it's, if, yeah, so we have to say, you know, my client's basement just flooded, so they think that they need a week to clean up the basement, get it back into condition to show it. I could take
Mhm.
it temporarily off the market. In the broker remarks, I would say property back on market no October 26th. Um, on October 26th, they call me and say, "Hey, Rick, we're the basement's still a mess. We need another week." That's fine. I just have to remember to go
Okay.
back in and change those broker remarks.
Okay. Got it. Good.
There's the MLS fees. We need to make sure that we're paying those. Those are billed every 6 months, $228 every 6 months. So we get those in March and September, I think. Yeah, March and September is when those are due.
Hmm.
Um, we don't see a lot of Supra access in our area, but every once in a while, if you have an agent from Stark County or Summit County, I think they use them a little bit more down in those areas. You might find an electronic lockbox and not a code to get into a house.
Yeah.
So you need a Supra, you need Supra access for that. We get that free from the MLS, so you just have to sign up and download the app, and that's how it works.
Yep. I
If you
got it.
want, if you want to use a Supra lockbox on your listing, they're much more secure. I wish we would use them in our area, but unfortunately nobody uses them, which makes it more of a hassle um, to get into the house when you're listing something and every agent's calling you that they don't have Supra access.
Mhm.
Um, but the idea is it's electronic lockbox, and if you don't have an account, you can't open the lockbox, and you can't have an account if you're not a licensed realtor. So you know that whoever's getting into your listing
Like,
is a licensed agent. We can't give out codes with the Supra. There is no
yeah.
combination, so it's all electronic. Um,
Gotcha.
we need to make sure we have photos in the MLS. You are required to have at least one photo, and that one photo has to be of the front of the exterior front of the house. If you
Yes.
do nothing else, you need to have at least the exterior front. You're allowed up to 35 photos, but if nothing else, just the exterior front.
Yep.
And then we can never advertise our service as free. We are not doing a free service.
Hmm.
First of all, it's not free because our clients pay us the $295
Okay.
additional commission.
Okay.
And um, even if even if you waive that, it's still not free because you're getting paid. You're getting paid by the seller as
Yep.
the business stands right now. That we'll see how that changes with the lawsuits that are going on, and
Hmm.
we've got a legal update next week.
Yep. I'll be there.
Okay, cool. Yeah, that
Yep.
it'll be a good one. Where Rich Cosgrove and I are heading down to Columbus for an Ohio Realtors um, broker summit. I suspect they'll give us a lot of information there. We're going to bring it back next week, so you'll want to definitely be on there. But we cannot advertise our services free. That is illegal because you are getting paid. Maybe not by the buyer, but you are getting paid.
Okay.
Um, some numbers that we need to be aware of is our office license number. Our
Okay.
office license number is on the screen right now.
Oh,
You can always find this on the state's website. If you want, you can check with me about it. It's also posted at the front of behind the front desk in our office. There's the actual physical license posted there, so the license number is there. But that's the 2020 number. Our
thank you.
EIN, that's our tax ID number for the office. You might need this every once in a while. You might need it if you're doing a HUD home, or you might need it if you are doing a referral. Either
Okay.
sending, well, not sending a referral, but if you're receiving a referral,
Okay. Yeah.
sometimes those brokerages will ask us for um, a W-9 or at least our EIN so that they can pay that referral fee. The MLS office ID is 9181. Everybody seems to get that confused with our office license number.
Okay.
Office license number, that 2020 number, is our license from the state of Ohio.
Okay.
MLS office ID, the 9181, is just an ID for the MLS. It has nothing to do with our license. It's just how the MLS identifies our office. There's also something called a NAID number. NAID is, I don't know what NAID stands for, but it's the number that you would need if you're ever writing an offer on a HUD home.
Okay.
If you're writing an offer on a HUD home, you have to go through their HUD system. You wouldn't write it on our regular contracts. You would
Okay.
go through the HUDhomestore.com or .gov. I can't remember, whatever the HUD website is, and that's when you'll need the NAID number. So you may want to take note of this one. Take a
Oh
picture
yeah.
of the screen or something.
I'm putting it in my contact information for KW Living right now. So
Yeah, so you may need that, and if you're writing an offer and you can't get a hold of somebody in the office and you need that number right away to submit an offer, then and there's deadlines on those offers, then you might want to have that handy.
yeah. Question with the MLS versus the office license number. When I've been writing offers, I've been using the 9181. Am I supposed to be using the office license number?
You talking about that last page where it
That
says
last page.
your name and your license number, office name, office license? Yeah. So that box on that contract, that last page,
Yeah.
the 2020 number is what's intended to be in there.
And when I'm looking at still that same page to fill out on the MLS, a lot of times I see a short number for the other brokerage as well. So should I be looking up the right office number, it sounds like?
You can look it up, or you can leave it blank and let them fill it in for you.
Oh, okay.
Yeah. If you want to be thorough, look it up on the state's licensing website.
Okay, but it's supposed to be that number. Okay.
Yeah. We also have something called an M1 number. It used to be called, and I think a lot of people still refer to it as your NERDS ID.
Okay.
That is your NAR ID number. So when you joined your local board, then you also joined Ohio Realtors and National Association of Realtors. National Association of Realtors is the one that issues that NERDS ID, or the M1 number. And that's you might be asked for it every once in a while. And if you go to NAR's website, you can always search if you forgot it. That is going to be your login for NAR. So if you're ever logging in for something, that's the number that you'll need when you log in. But again, if you don't know that number, when you go to the login, there's a lookup button for it too.
Okay. 2 seconds. Let me put that last one in for. Oh, that's not. I'm sorry. So the brokerage doesn't have one?
No, the NERDS
just agent.
ID is your own number. I have
Just the
one.
agent.
You have a separate one.
Okay.
Every NAR member has their own unique ID number. Okay.
Got it.
Commissions. This slide might start changing now with what's going on in our business, but for now,
Yeah.
well, what won't change is antitrust laws, and we are not allowed to have conversations outside of our brokerage about commissions.
Okay.
It means if you're friends with an agent at another brokerage, you are not allowed to talk about, this is what I charge, how much do you charge?
Okay. Yeah, that's right.
Conversations are off limits. That can be an antitrust law violation.
Yeah, I remember the examples in the agent books or whatever. I remember that. Okay.
Co-broke commission. So we always put in the MLS what the commissions are. So if it's your listing, you're going to put in a co-broke. If it's your buyer, the MLS is going to tell you what the buyers are getting. It might be a 3%, it might be a 3.2, it might be a 2.5%,
Yeah.
it might be a 1%. Whatever's in the MLS is our contract with the MLS. So whatever's in there is what you're getting paid. It's not up for negotiations.
Yeah.
Sometimes agents will say, call me and say, hey, Rick, are we doing an even 50-50 split on the commission? And my answer to that to them is the buyer agent commission is in the MLS, and that's what we're agreeing to pay you. It's not up for negotiations.
Okay.
So now if you have a exclusive buyer agency agreement and you come across a listing that's a 1% and your exclusive agreement says that you work for 3% minimum or a 2% minimum, whatever you put in there, then your buyer knows that, hey, this one's, you would let your buyer know that, hey, this listing's only paying me 1%. Our agreement was that I don't work for less than 2%. You have to pay me the other 1%. It's in the agreement already, so that's how you can protect yourself.
Okay.
There's the additional commission, that's $295. That is something we charge to our clients all the time. So if it's on every deal, whether it's your listing or your buyer, we charge that additional commission of $295. The only exception is if you are a buyer's agent and your buyer is getting an FHA loan or a VA loan, or if it's a bank-owned listing, or if it's a short sale listing, then those are excluded from the additional commission, because those are rules with the institution or with the loan type, that borrowers are not allowed to pay those extra commissions. So that's the only time that commission is waived. Now, when you submit your commission, Ricky does not have a way to know that this is a VA deal or an FHA deal. So when you submit that, you're going to have to make a note that says, hey, this is VA, don't take the additional commission. Otherwise, he's not going to be aware of that. He's just going to get the commission check and take the $295 out of it. So you also won't get paid if you don't have all the required forms turned in. So we audit those. We have somebody that is very thorough in auditing those. And if we're missing anything, you will not get paid. So if it requires a lead paint disclosure and you skipped it, it's closed. We got your commission check sitting in the office, and until you get that uploaded correctly, then you cannot get paid. So it's really important to make sure that you have a complete file.
Yeah.
That's for everybody's protection, in case there's a problem later on. By the way, one of those required forms that we should talk about is the home warranty form.
Okay.
The home warranty order form is a required document in all of our transactions. If they're accepting a warranty, there's a spot for them to sign that they accept it. And if they're waiving it, then there's a spot at the bottom where they can waive it.
Yeah.
That's a requirement. And the reason that's a requirement is because America's Preferred Home Warranty will help us in our legal defense if there's a lawsuit with a particular transaction, as long as our client had an opportunity to take a home warranty. They didn't have to take the home warranty for us to get that benefit, but we need to show America's Preferred that we did present them the opportunity to get it, and then they'll help defend us. There's showing time, so we use showing time. You're probably familiar with that one already. So when you put it into the MLS, it sends it over to showing time for us, but you're going to have to log in to showing time to put in the instructions if it's a go and show. If it's also when you're booking for your buyers, most brokerages are using showing time. So I think 9 out of 10 times, or maybe even more than 9 out of 10 times, it's going to be through showing time. So you'll need that login to schedule for your buyers as well.
Yeah.
You're going to get an email for feedback. I would encourage you to provide feedback when it's your buyer showing. Give them some sort of feedback. I'd like to have feedback when it's my listing, so I try to be courteous and provide feedback when it's my buyer that I'm showing somebody else's listing.
Yeah.
If there's times when the seller does not allow you guys in there, you can always block those out. You can say no, you can create a rule that says no showings after 6 p.m. or no showings before 9 a.m. or, you know, however you need to set it up, you can set that up. There's also showing reports, which are really helpful to use. If you've got a listing and you aren't getting the showings that you'd like to get, you can go into showing time and you can see that other similar properties. You can't see which property, but you can say South Euclid between 150 and 200, and you can see that, well, nobody is getting showings, or everybody else is getting showings, and how come we're not? Or maybe you're priced at 150 and you see nobody between 150 and 200 is getting showings, but people between 100 and 150 or 125 and 150 are getting showings. That might be a conversation to help you with the price reduction as well.
Okay.
Setting up your listings and showing time. You can do appointment required to go and show, or a courtesy call. Those are the three options. Go and show means seller doesn't, you'll still as a listing agent know that somebody's going, but the seller does not get notified of that showing. Appointment required would be the opposite. They're going to call the seller and say, you have a showing request tomorrow from 1 o'clock till 2 o'clock. Can we approve that or not? And then your seller will say yes or no. And then the courtesy would be, so one is for occupied houses, one's for vacant houses, basically. And then the middle choice is a courtesy call. So sometimes I have vacant houses where the seller says, well, I still want to know. I don't have to approve it, but I want to know that somebody's there tomorrow between 1 and 2.
Yeah.
So they'll, showing time will approve it for them, but then they will let your client know either through a phone call or a text message.
Okay. Good.
Questions up until now?
No, that was great.
Okay, cool. So who signs our contracts, whether it's a listing or a purchase agreement? Are they a single person and just one person needs to sign that listing or purchase agreement? Are they married? Both signatures should be required if they're married. Even if they tell you that only one person bought it and the spouse is not on the deed, if they're married, or bought it before we were married and now I'm married, both of them need to sign it.
Yeah.
If it's a trust, you need to know who the trustee is. You should see the trust documents that name the trustee. The reason being is that there's so many different ways trust can be set up. It can be a co-trustee, you can be a successor trustee, you can just be the only trustee. And so you need to know that the right person is signing it. Same thing if it's an estate and there's multiple siblings. I had somebody passed away and the siblings listed dad's house. There was 4 sisters and all of them were married. We had to have 8 people sign everything.
Okay.
Divorce. Are they already divorced? Sorry, I need to.
It's okay.
Move around here a little bit. Sorry.
No worries. Yeah.
Sitting too long today. So if they're divorced or getting divorced, you need to understand if they are divorced, make sure you're getting the right person to sign everything on a listing. Make sure that there was, I find oftentimes in a divorce decree, they'll give a house to one spouse, but and there's a quitclaim deed somewhere, but nobody ever bothered to record it. So the public records still show that there's 2 of them owning the house. So you need to make sure that whoever kept the house, whichever spouse kept the house, that it's reflected correctly on the county site. If it's not, it wouldn't be the first one. And you just need to make sure that there's an attorney with a quitclaim deed that can get it recorded, Or what I've done is I've taken a copy of that quitclaim deed that was not recorded, given it to our title company if they record it simultaneously with your transfer. So at least they know and they can ensure that.
Oh, okay.
And then there's dower rights. Dower rights is just about the spouse. So it takes one to buy, two to sell. We're one of only 3 states that still have dower rights.
Mhm.
Ohio, Arkansas, and Kentucky are the only 3
Mhm.
states left that have dower rights. Escrow letters, this is how the title company is going to know uh, how you're getting paid, who's getting paid, how much you're getting paid, what else is getting paid out of closing. So there's you'll fill it out. It's pretty self-explanatory, and I think you've already done 1 or 2 of these because you've had a few closings.
Mhm.
So it's self-explanatory. You're going to fill in the buyer's name, seller's name, contact info. If you don't have the other client's contact info, skip that. Your commission, is there a home warranty and who's paying for it? Is there any closing cost credits or anything like that? And yeah, so